Thank you. Oh, what a beautiful morning. Oh, what a beautiful day. And yeah, I looked outside. It's really not that beautiful, but somewhere in the world, it really is. I've got a wonderful feeling. Everything's going our way. 'Cause I'm here from the GSA. All right, we're gonna get started. That's not me. Okay. All right, who am I and what the heck am I doing here? My name is Rich Butterworth. I'm a senior advisor in the Public Building Service for General Services Administration. I almost said Office of General Counsel because I was in the Office of General Counsel for GSA for a little over 31 years, went to the private sector, saw the error of my ways, came back to GSA in a program role. And while I was in the Office of General Counsel, I was, one of my duties was to serve as the Chief Counsel for the Office of Real Property Utilization and Disposal. And so now I'm a senior advisor for that. So one of the first things I want to do is just say, okay, so again, still, Rich, why are you here? I was contacted by Sarah Lawson about 6 months ago, 6 or 7 months ago. Do you guys know her? She was referenced in another session. And wanting to understand how tribes have an opportunity, or do they have an opportunity to acquire real property through the real property disposal process of GSA. And I kind of explained it all to her. She said, so can you please come and speak to us here in April? So I said, okay, sure, I'm happy to do that, and that's why I'm here. But I don't want to assume that any of you know who or what GSA is. And the reason why is because even though I'm in DC, and so you would think everybody would know, almost all the time, everyone thinks I'm the GAO. And that's the auditing group. They're the nasty people you don't want to see, come up. They do all these terribly long reports that really don't say anything and make any conclusions. No, we're not them. I'm also not the IG. I also don't do the really bad investigations. That's not me either. So who is GSA? Well, GSA is an agency that was created in 1949, and it has two big houses. One house is the Federal Acquisition Service, and some of you may be familiar with that. They have a schedule of goods and items, from everything from pencils to bison, that people can try to acquire. Other federal agencies primarily, but also tribes are also authorized to use the system. They also have a separate personal property donation program. I'm not talking to you about that. There's a separate side of the house, it's the Public Building Service. That's the real property side of the house. So we do everything from leases to new construction to managing buildings. So all the federal courthouses, the downtown federal buildings, used to be all the post offices, those were all GSA inventory. And then I work in the Office of Real Property Utilization and Disposal. So this gives you a little history of everything that went into the creation of GSA. GSA in 1949 was created to kind of pick up all of these authorities that existed from after World War I through the Great Depression and through World War II. So you see things on there like the Works Progress Administration, the Federal Art Project, the Reconstruction Finance Corporation, Defense Supplies Corporation, things like that. And then you see stuff spinning out of GSA. So originally the National Archives was part of GSA. The Strategic Stockpile was part of GSA. And then NARA, the emergency programs, until they switched over to DLA within GSA. So we have really broad, or had, really broad authority, but we still do. We provide service to the entire federal government. So in the area of real property disposal, we have very unique authority. We have authority to dispose of federal real property from all executive agencies. And we have a very specific process that we go through, and that's primarily what I'm going to be talking to you about. I'm going to try to give you a little bit of this is how we dispose of real property, what that process is, and then I'm going to focus more specifically on places in that process where tribes are specifically recognized. This is how my office is split up. And just so you know, I mean, you can take notes. All of the slides and everything, the presentation is going to be made available to you. I think if not already on the thumb drive, it's going to be out there for you. I will tell you there is one thing that I put on a slide after I sent the stuff to Nicholas, and I will tell you what that is so that you can write that piece down. So instead of GSA itself has 11 regional offices across the United States. Including one regional office in DC in addition to headquarters. However, the Office of Real Property Utilization and Disposal has 5 zonal offices. And what I've provided you here is the contact information for each of the directors for those 5 zonal offices. So Atlanta, Fort Worth, San Francisco, Boston, and then the one in DC. The Boston office has a satellite office in Chicago. The San Francisco office has a satellite office in Auburn, Washington. And then we have remote people in some of our other zones. All right, this, in kind of a thumbnail sketch, is our disposal process. It all starts with a federal landholding agency making a determination that it no longer needs federal real property within its inventory and declares it excess to that agency. Every federal agency can determine how that process works within the agency. So for Department of Interior, who has a number of different bureaus, often what will happen is it'll get screened internally within the different bureaus unless it's property that only that one bureau can use, and then it might get declared excess to GSA. Other agencies simply do the stovepipe right up to the decision maker, and then it comes to GSA. For GSA itself, we have varying grades of requirements with regard to who has to sign off on a determination to excess property. If it's a small property, if it doesn't have federal tenants in it, they've already vacated, that can usually be done in the regional office. For larger properties that will also require tenant moves, that will have to be approved by our headquarters office. The first thing we do after it's declared excess, sometimes even in advance of getting the report of excess, we do a federal screening. And I'm going to talk about this a lot more, but just a thumbnail is we send a screening notice to all federal landholding agencies, letting them know that this property is available and giving them an opportunity to acquire it. And like I said, I'll talk about that a little bit more. If no federal agency wants the property, then it's declared surplus to the federal government, and then it goes through a second set of screenings. It's screened for a number of different public benefit uses, as well as negotiated sale. Under the public benefit use provisions, those are places that Congress has authorized conveyance of property for less than fair market value for a number of different public benefit uses. Everything from homeless use, which is the only non-discretionary screening that we do. It has various prescribed periods of time and screening requirements. And then everything else is discretionary, but we generally, if we've got something that's a downtown building, we're not going to screen it for park and rec purposes, for example. But and we have one for historic monuments. So if the building's not historic, we're not going to screen for that. But otherwise, we pretty much screen for everything from emergency management, corrections, law enforcement, education, health, homeless, self-help housing, park and rec, and there's a couple more, I'm sure, airport and road widening. So it's pretty vast. Each one of those uses has what's called a sponsoring agency. So that means there's an agency within the federal government who determines what the program of requirements are. So an easy one, education is Department of Education. So an entity, either a public entity or a nonprofit, is interested in acquiring property for education use, then they submit an application to Department of Education in accordance with their requirements. If Department of Education decides that that's a good use, after reviewing the application, then they send a notice to GSA. We assign the property to education, and then they convey it for that education use. These conveyances come with a restriction on the use that's consistent with that program of requirements. Some of them are for 30 years, so homeless, health, and education are for 30 years. Others like park and recreation, historic monument, those are in perpetuity. And those deeds typically have a reversionary provision that allows the government to enforce those conditions. Most of the sponsoring agencies, and in some instances GSA, we have oversight responsibility. We do basically a 5-year physical check with annual self-certifications. I think that's what most of the sponsoring agencies do. If the property is not picked up for either a public use or negotiated sale use, which is available to only to public bodies, then there's opportunity for public sale, which is a competitive process. So again, the difference between excess and surplus. Excess property is when a federal agency has made a determination that it no longer needs that property for its own mission purposes. That's declared excess in a report of excess that comes to GSA. After screening with the other federal landholding agencies, if no other federal agency has expressed an interest in it, then the property is declared surplus to the federal government, the entire federal government. And that's when it's available to be conveyed outside of the federal government. So what are some of the limitations? I've said that this is a really broad authority, and it's true. It does cover all executive agencies. Even agencies that have their own disposal authority, they can choose to report property excess to GSA rather than using their own disposal authority. Well, why would they do that? Well, sometimes their own disposal authority can be cumbersome, or maybe there's a local interest in doing a public benefit conveyance and their authority doesn't contemplate that. Or other times it's just they've lost the realty expertise. That is one of our core mission objectives, is real estate expertise, whereas other federal agencies don't have that as a mission need. So they may report property excess to us. We also work with other agencies under their authority through a reimbursable basis. But within the definition of real property for Title 40, U.S. Code Title 40 is what we operate under. There are some exclusions. So real property, the definition of real property for our authority does not include public domain lands or lands reserved or dedicated for the national forest or national park purposes, and also the withdrawn lands for BLM. So unless it is removed from that oversight, from that designation, so it's either removed from the national park, national forest, or BLM determines that that property is not suitable for return to the reservation, to the reserve status, then it doesn't come to us. So I just wanted to make that clear. However, we do get instances where BLM has determined that there's property that's been in use by another federal agency, and as a result of that use, even though it's within the boundaries of their withdrawn, their public domain lands, they determined it's not suitable for return, and so then it's declared excess. Yes?
What kind of criteria would trigger a determination not being suitable for return?
Some of them have been the amount of development by that federal agency. In some instances, it's because of environmental contamination that hasn't been dealt with. And sometimes it depends on whether or not it's contiguous to other portions of what's within their inventory. So whereas it might have once been part of the overall withdrawn lands, it's separated by either roadway or whatever, or other lands have been disposed of in a different manner, and now it's remote. So they've determined that it's no longer qualifies. So those are some reasons. Yes, sir?
Thanks. I may be jumping ahead, but has the done, since the federal government holds the legal title, has the GSA done a direct trust transfer? So that only really that you're creating a beneficiary in the tribe?
I will get there.
Okay.
However,
All right.
but I'll go ahead and answer the question. We don't have our authorities our authorities in our process that recognize tribes only recognize them through BIA, Department of Interior. So we don't have authority to convey directly to a tribe. However, what I will say, and certainly not for trust status.
Yeah.
So what I will say though is that when I mentioned before in our disposal process under the public use conveyance, I did hear a couple times yesterday that individual members of tribes had set up nonprofits, 501c3s perhaps. Those are, applicable, depending on what your program or purpose of use is. So it is important, and I'll get to like how do you get information about when's property available. I'm definitely gonna cover that. So whether or not you're interested on behalf of the tribe or separately, if you have a nonprofit that might be interested in property, that might be of use for you.
So, I'm sorry, one quick follow-up. If that land then is transferred to the tribe, then the tribe assumes the cost of environmental review and title review. Do you know whether the Department of Interior has developed a process whereby it is willing to rely on the environmental review and the marketability of title essentially from the United States to the United States?
Right, all right, so let me back up a second. When we receive a report of excess from a landholding agency, we have a checklist, a report of excess checklist, where we require a significant amount of environmental due diligence from the landholding agency. Now, the one tricky piece with regard to our relationship with DOI specifically is that, as you pointed out, all federal real property is owned in the name of the United States, not the individual agency. So when we transfer property from one federal agency to another federal agency, there's no change in title. It's just a transfer, and we do that through an administrative process. The thing with that is that you don't need to have the same amount of environmental due diligence as you would if you're going to convey outside the federal government. It's really just a decision between those two federal agencies. Have you done enough? Have you not done enough? What's that environmental agreement between those two agencies? And that has been a bit of a hiccup in some transfers to Department of Interior. Whereas the landholding agency, let's just say it's Army, for example, feels like they've done a good job of characterizing the property. There is environmental contamination there, but it could be conveyed with use restrictions. It could be conveyed with a commitment for additional cleanup if that was necessary. There's different mechanisms in which you comply with CERCLA that don't require a full cleanup necessarily. And so, but Department of Interior is reluctant to accept that. And we have had some instances where the tribe has been quite willing to accept that. They have an environmental contractor as part of the tribe. They have their own environmental due diligence teams as part of the tribe. They understand what the characterization is, but it's still been kind of tricky getting that through Department of Interior. I really think. Here's some other limitations. So excess property is only available to other federal agencies. So when it's in this excess stage, only federal agencies can apply for them. For the public benefit conveyances, I already covered that, but just as a reminder, that's below fair market value, or typically it's for no cost. All of them are open to state and local governments, and in some cases, nonprofits, but tribes are not included in that definition. Negotiated sales are limited to state and local governments because the underlying assumption is we should do competitive sales rather than negotiated sales. But there is this limited exception for public bodies. Again, tribes are not included in that particular definition. There's also one for.
Tribes are not included in that definition?
I'm sorry?
Can you tell us why tribes are not included in that?
I don't know. It's just the words that are used are clear that it's only state and local governments. And there are really, this is pretty long-standing solicitor opinions on both the public benefit discount conveyance side as well as the negotiated side, that when Congress passed, I mean, they said very specifically state and local governments, and so not tribes.
So that's a statutory.
That's a statutory, right? Both of those limitations are statutory. It's not regulatory.
So that even if the federal government owns land within tribal reservation boundaries, we're not allowed to access and get a right to bid?
Okay, see, you're running ahead. I'm almost there. These are limitations. These are obstacles, but I'm going to give you a couple pathways.
So were tribes specifically excluded?
No, their tribes are not specifically
So they
excluded.
could not be considered local governments?
No, not in the land because they're tax-supported sub-entities of the state. So it's how it was written. Got it. This just gives you a breadth of the kind of stuff that we get. Everything from an island to a lighthouse to vacant land to federal buildings. So we've kind of seen it all. And so one of the benefits with GSA also is because we have seen it all, we don't get too uptight about the type of property that comes to us for disposal. We've seen all kinds of contamination, we've seen all kinds of uses, whereas each agency typically only has a couple different kinds of property types that they're used to. So we tend to be a little bit more flexible in terms of how we understand environmental conditions and requirements, and also how to think about transactions a little bit more creatively. So I wanted to talk just a minute about the Fed-to-Fed transfer piece so that you understand this before I then go into opportunities for tribes. So in a Fed-to-Fed transfer, it's not just a no-cost transfer. Feds are required to pay fair market value when they request property from another Fed. Now that might not make a lot of sense, to the outside, like left hand, right hand, why are you paying money? But each agency has their own appropriation, both for acquisition as well as for maintenance and operation. So Office of Management and Budget is in the statute given authority to determine along with the administrator of GSA, how this process between federal agencies works. And what they said was, we want to make sure that that agency has sufficient resources to take on this property that they're going to acquire. So you can't just say, oh yeah, I want that, oh I want that, oh I want that. No, you have to show that you have a program need for it, how you're going to use it, and you have the budget in order to carry it out, and that includes the acquisition budget. There are some exceptions where you can get a waiver, but I will say, I don't know. I think, am I one of the only feds here? But I'll just say that dealing with Office of Management and Budget is a pain in the butt. And our budget examiner, I've been around long enough that I remember when she was bright-eyed and how can we help you? Yeah, no, not anymore. It is, how can I say no in every way possible? And, oh, damn it, you reminded me I said yes once. Guess what? Today it's no. So those waivers are very difficult to get, even on ones that we are fully supportive of. Like one of the easiest waivers to us is when one federal agency has been occupying, paying for, managing a piece of real property, but for whatever reason it's history, it's in the inventory of another agency, and now they just want to clean it up. So for us, it's like, well, that's no cost. They've been managing it, they've been incurring the cost for it, that's for them. And so we support that kind of waiver. It still has taken us over a year to get an approval of something like that. And that's generous. So where are tribes thought of at all in this process? And I'm really sorry that they're not thought of more. But this is the one spot in 40 U.S.C. 523. This is specifically for federal properties within tribal boundaries. If we get, it's for federally recognized tribes and within their designated boundary. So I recognize that there's some limitations there because there's some tribes that don't have recognition, and there's some boundaries that there might be some dispute. But if we get a report of excess of that type of property, it is mandatory that we transfer that to the Department of Interior at no cost to be held in trust for the tribe. So how does that designation happen? And I will just say, so the secretary then, and this is also specifically in statute, cemetery holds the property in trust for the tribe within that reservation. And then there is just to finish the whole provision, there's a special requirement for Oklahoma. So just for the state of Oklahoma, it can be within the boundaries of former reservations or contiguous to real property presently held in trust by the government for an Oklahoma tribe. So Oklahoma's different. But for everyone else, it's within the reservation boundaries. So how does that get identified? That gets identified really in kind of two different ways. Often, when we receive a report of excess, we are told by the landholding agency that it's within a reservation. Or that landholding agency or the GSA Realty office that receives a report of excess has been notified by the tribe that it's in the reservation. But to be sure, we always screen with Bureau of Indian Affairs. So they have the responsibility for that formal determination that it's the federally recognized tribe and it's within the reservation boundaries. And then we do the transfer. And then this has never really happened, once in the history, because obviously the question came up. It's at no cost to the tribe, is what it says. There are some federal agencies that operate under a revolving fund who are required to be reimbursed for any disposal of their real property. In those instances, DOI would be responsible for paying them the fair market value, not the tribe. But that's never happened in my experience. I just know it because I have the old files. So here's the process. So when we receive a report of excess, or even are aware that a report of excess is coming, we begin our federal screening. That includes BIA. BIA would then identify that the property is subject to this requirement. We work through any issues with regard to environmental or other kinds of problems, and then we transfer it. We have a letter of administrative transfer that goes from the original landholding agency to the BIA, who acknowledges receipt, and then they go through the trust process. But it's to be held in trust. So that's its status once it hits BIA. So here's an example of one that we did for the Pitt River Tribe up in the Shasta Trinity Forest in California. This was a former Forest Service guard station, I think. And it wasn't a huge piece of property, but this is a good example of that kind of transfer. So, any questions about the 523 transfer authority? Yes, sir.
This is probably a bit overly specific, but what would happen if you receive at your agency's property where part of it is inside of a reservation and part of it is not? Would you sever it, send the part that's in the reservation to BIA and keep the rest for whatever the rest of the process is, or would it go as a parcel?
So let me give you a little back. Let me give you a more general response and then think specifically about your example. When we get reports of excess, we are thinking all the time about how can this property be disposed of. Sometimes we get huge tracts of land, like 500-600 acres. And so does it make sense for us to think about going through the process like that? Or are there reasons to parcelize? And when we parcelize, we want to make sure that any of the individual parcels are still marketable. They still have access. There isn't if there's an environmental issue, it's not concentrated on one, but it might be shared unless it makes sense to concentrate on one. So it's really dependent on the circumstances of that particular piece of property. In your example, I do think there have been a couple instances where properties have been like that, where part of it has been within reservation boundaries and part not. And we have separated that. Now, I would think that the exception might be where we would be left with an uneconomic remnant. And then I think that we would have to enter into negotiations with BIA on how that would go through. Any other questions about 523?
That specific, 523 is specific to excess property?
Yes, so it's right up at the top. It happens right at the beginning. So in general, Fed need is always first. Now our issue is, so in our screening process, let's just say, the train has gone down the track, and now a federal agency says, oh, we realize we have a need for this property. What does GSA do? Again, I'm gonna say it depends a lot, but it does depend on where we are in that process and what has occurred. So as I mentioned earlier, one of our screenings is mandatory, and that's the McKinney-Vento Homeless Assistance Act. That has very specific requirements. Once it enters that process, it can't come back out until it completes the process by either completed application or it's not going to be paid under that authority. So if it's in that process, then even if it's a federal need, it can't come back. If we have taken a property through that process and now we're either in negotiations for a negotiated sale or we've advertised it for sale and it's being actively auctioned, it would have to be a very extreme requirement. So I think if the property was within reservation boundaries and for some reason it just got missed, I think that would be an extreme example. But in most instances, it would be very difficult to call the property back if it was in one of those stages.
So there's, say, US Forest Service lands that are either in a reservation that was originally a lot, there was an original allotment and somehow it ended up in federal ownership, or after allotment, there were excess properties that became federal lands. Those lands, if the tribe wanted to acquire those lands, wanted those back in tribal ownership, they'd first have to go through the step of the federal government to label those as excess
Right.
before they could go through this, or is that a whole separate statute?
Yeah, they would have to release it because GSA's authority kicks in with that report of excess. Now they may have some other process within Forest Service to do this more directly, but for this authority, they would have to declare it excess, which is a fairly simple process actually. It's all online. We do trainings for realty specialists and other agencies all the time. Forest Service is one of those that we would work with quite frequently. This is the other opportunity in statute for tribes to acquire property, and that's the Indian Self-Determination Education and Assistance Act. For the longest time, there was provisions in there that were specific to personal property. And then in the 90s, it was amended in an Indian Arts and Crafts bill that added the words "or real" wherever it had the word "personal," but it didn't provide any new process. It didn't provide any new explanation. There was just nothing else. So I'm going to tell you kind of what the authority is and then what the process should be. My understanding is, and the reason Sarah asked me to come, is I'm not sure if BIA in the regional offices or maybe even in headquarters really understand this very well. So I'm hoping that you will understand it very well and ask me all of your questions. So under the authority, there's 3 opportunities for Department of Interior to donate property to tribes. First is, that's the first one, that they can permit an Indian tribe or tribal organization to utilize existing school buildings, hospitals, and other facilities and equipment under the Secretary's jurisdiction. So as long as it's under Secretary of Interior's jurisdiction, it can be donated to the tribe. Secondly, Department of Interior can donate to a tribe or tribal organization title to any personal or real property found to be excess to the needs of the Bureau of Indian Affairs or the Indian Health Service. So it doesn't have to go through that GSA process. Within those agencies, if they determine it's excess, then Department of Interior can donate those directly to the tribe. And then the third provision is this one, that the Secretary is authorized to acquire excess or surplus government, personal, or real property for donation to a tribe or tribal organization if the Secretary determines the property is appropriate for use by the tribe for a purpose purpose for which a self-determination contract or grant agreement is authorized under this chapter. So you have to have a contract, and you have to kind of explain how the real property would assist in carrying out the contract goals. Meet those two criteria, and then the Secretary of Interior can put in to acquire the excess, or in this, or surplus. The reason I say this is a little weird because, like I said, for the longest time, it was personal property only. They have a different disposal process. It's a little bit more fluid, and the personal property can flow back and forth from surplus to excess a little bit more easily. So it didn't really matter. A secretary could acquire either excess or surplus. We have a more regimented process, so it created some administrative issues of how we would manage that process. But essentially, that process looks like this. So we're screening excess property, right? And we're screening it with the other federal land holding agencies, which includes BIA. During that process, in addition to a 523 transfer, the secretary can also identify a contract need for that real property. So outside reservation boundaries, but could be used to help with the contract. So BIA notifies us of the request, and that generally is driven by the tribe. So it helps for you to know what real property you're looking at, what real property possibilities there are, so that you can drive that process. And you can drive that process in one of two ways. You can drive that process through BIA, or you can drive that process by directly contacting GSA so that they can be ensured that BIA is aware of this. So then what we do is, I'm reminding you that in the Fed transfer process, typically, Fed has to pay fair market value for that acquisition. That's why it's important that the third provision says the secretary can acquire. So what we do is we review the contract requirement against those public benefit discount advance authorities that we have. If the contract purpose matches one of those, or was in the rel, so if it's for education use, if it's for park use, if it's for health use, if it's for cultural preservation use, then we would support a waiver. Again, it has to go through O&B, but we would support that waiver. If it's for economic development, though, then fair market value needs to be paid. Now, often BIA claims that they have no money for this, so when we have done these, typically the tribe does pay through BIA. They have worked out a mechanism so they can accept payment. This was 555 acres up in Maine that was paid. I think they paid, one thing is like around $500,000, $500,000 to $600,000 for the 555 acres. So I think this is one of those areas where there have been some hiccups in the process, where more likely if there's an issue with the nature of the contamination or the intent of the contract use or how the two are going to flow together, GSA is just trying to match. We don't get involved in a lot of those granular details. It's just more in terms of, does this meet something that we would support as a waiver of fair market value, so that we can go to OMB for that waiver, or is it one in which fair market value needs to be paid? Okay, so what questions do you have about this process? Yes, sir.
So GSA has a consultation requirement when it comes to tribes.
Yes.
Does GSA have a policy on how they execute that consultation? Because it seems to me that there are a lot of things out there. I'll give you an example of the Seattle National Archives that came out.
Right.
There are a lot of examples where tribes need to be consulted, but they're not going to know about it unless GSA, which knows about it in the first instance, raises the potential of the consultation. So what is your
So I'm gonna answer that in two ways. First, I'm gonna say, help us help you. Help us help you. Because we want to consult with tribes. We're often looking to other parties to tell us who those tribes should be. So in any disposal that we do, we're required to comply with BEPA and with 106 of the National Historic Preservation Act, both of which have consultation requirements. And we reach out either through our environmental team or through the SHPO, or if we know that there's a tribal historic preservation officer, we reach out through them for who we should be sending consultation letters to. We also keep a record of tribes that have gotten in touch with us with regard to properties in certain areas. And so we take that very seriously, but we need to know in advance. So during our process, we don't just screen with BIA. We're also taking information that's been provided to us by the landholding agency. We also keep records of contact from anyone who's expressed interest in property that may not have even been recorded as excess yet. There's also, I'm going to tell you, there's also in our online information, you can sign up to get electronic notices for excess property and for surplus property. And I have the websites available for you at the end. So you can be notified, and you can determine that across the country, or you can determine which states you might want to focus on. And then at the same time, I've given you the contact information from each of our zone heads. And if you just want to contact them and say, hey, I represent the fill-in-the-blank tribe, and we are really interested anytime property comes within this area, I'm the contact person for that. Now, we undergo, overhaul of people all the time like everyone else, but we do have a multi-layered process. And we've reissued, we've always had a tribal consultation policy that was issued from our administrator that was recently renewed and put back out by our current administrator. So we do take that very seriously, and we have a separate tribal consultation office in the administrator's office, off of the administrator. So does that answer your question? Great. Other questions on Self-Determination Act? So it really, this one is pretty broad. The one other difference, hold on just a second. I just thought, the other major difference between this and 523, by statute, that property goes into trust. Property under this provision is treated as fee. It's a conveyance from BIA to the tribe. And that if you want that property to be held in trust, then you have to go through the trust process. But it would be conveyed in fee. Yes, sir.
So, with 5324, could the process work in the opposite direction? Tribe goes to the BIA, says there's this piece of excess property, we want you to get it and transfer it to us, and they come to you, or when they go for excess property, are they going to have to show some kind of a need other than the tribe when they go for excess property?
No. Their mission need is to serve the tribe under either of those two provisions, under either 523 because it's within reservation, they are required to take it. Under the Indian Self-Determination Act, then yes, their mission need is to supply, to be able to donate under this authority. So they don't have to have a separate mission, purpose, or need, or anything else. It really is the need that you put forward. Yes, sir.
So the 5324, in all essence, would be for all lands that are within the ceded territory and not just within the reservation boundaries?
I believe that's right. Wherever you're authorized to carry out a contract. And I believe that can be, it's not necessarily tied to reservation boundaries, right?
Right.
Yeah, that is correct. And I think that's why that property is conveyed in fee, and why you have to go through a separate property process for
So then
trust.
we would just have to determine what
your benefit because the fallback is gonna be economic development, which would require a payment. So it really is to your benefit to think about how this would benefit the tribe. Because number one, you have to have a contract in place, and so that has to have a mission purpose, right? But it also assists you in being able to get the potential of a waiver of that. Might take a delay, but unfortunately with OB, but for us, that makes it easier. So if it's an education use, a health use, a park use, so like I said, cultural heritage use would fit under our historic monument provision. So any of those would be a no cost, we would support a no cost transfer. Yes?
If you were to get it for cultural preservation, and then later on, you wanna change it, or they decide to start developing, would there be like some type of like reimbursement payment that would need to be incurred?
So this is a little tricky for me to answer, and I'll explain why. I know what it is on the regular property disposal side. I've got sponsoring agencies, I've got applications of use, I've got a deed that has specific provisions in it, that has requirements, including a reverter provision. We have a process for dealing with those that would authorize either abrogation of those restrictions by payment of fair market value, or you could transfer the restrictions from one type of public benefit use to a different kind of public benefit use. Since these would be done under the contract, that's really all managed by BIA. So if they didn't deed it with a specific deed provision in it, other than subject to the contract, then it really is the terms of the contract that you have to go back and look at. Can the contract be modified to change the use? Can the contract be done, or what's the term of the contract? We're not really involved in that. Does that make sense? Okay. Any other questions about that piece? Yes?
Just on the revisionary ownership.
Yeah.
From the deed of trust applications that I process, the BIA and their opinions and their attorneys' opinions, when they see those kind of language restrictions, either on title, on deed, on title assurances, usually they're pretty scared to place a property into trust. The trusts have problems with that kind of revisionary language on the actual conveyance documents, placing those properties in trust status, and the house of BIA, and their interim and preliminary title appeals looking at that kind of language.
Got it. So first I'll say, just from practical experience, I haven't seen a tribe take property like under our regular provisions that would have those deed restrictions where we're either involved with the deed or making recommendations for what the deed looks like, because they're not coming in under a 501c3 status. So BIA does all of the other deeds. My response would be that if it is a reversionary provision or something like that back to the government, if they're gonna hold it in trust, that merges title and that reversionary provision goes away. So I would think that that would not be an issue or shouldn't be an issue for them, as long as that interest is not for the benefit of someone outside the federal government. The provisions I've been talking about are ones that are intended to protect the government's interest in making sure that that public benefit use actually occurs. So that taxpayers get their benefit. That's pretty much it. Does that make sense? I mean, the thing is it doesn't happen very often that tribal property will be conveyed with that kind of use restriction in it from this process. So I don't think you're gonna see it. What I'm saying is, if in the off chance that you do, when they're bringing it from fee into trust, that's gonna merge the title. And what that means is, my interest in the reverter, I'm now holding it in trust, so that merges it, so that reversionary interest is gone, because I've already brought the property into trust back into federal kind of ownership. Does that make sense? Okay. Other questions? Okay. So in this, in response to your earlier question here in front, this was an instance where this portion of the property was available, and so we did the conveyance. Like I said, it was under Self-Determination Act. There were other portions that might have become available at a later point in time, but they were subject to other requirements, other state requirements, and so it fell outside of what a tribe could actually hold title to. It's for some reason. I wasn't involved in this particular deal, so. And then at various points in time, Congress has recognized some unique situations. I just wanted to point these out to just say that they're out there and you can review them. Each of them are very specific to that land mass. So the Hawaiian Homelands Recovery Act, this is something where they determined that because the federal government had acquired so much property within within Hawaii, that the Native Hawaiians were due a specific payment. And it could be in the form of real property. So as real property became available, it would go against that overall amount of money that was due and owing the tribe. Alaska Native Claims Settlement Act was a little bit different, same premise, but instead it created points. And so the tribes there could use specific points in order to acquire federal real property based on the points in the system and what the property was that was available. And then the Guam Excess Lands Act, that was a little bit different there. They specifically designated certain real properties within Guam that if they became excess to the federal government, could potentially be acquired by the Guam Lands Commission. And so we did recently, just last summer, we did a transfer under the Hawaiian Homelands Act to the Hawaiian Homelands Trust, 80 acres. That was a $10 million valuation. I think the overall requirement is about 18 million. So that represented a little bit over half of the overall requirement. Already to that, I want to get to this. These are the resources here that I want to make sure that you have that are not on the slides that you'll get on the thumb drive. And that's realestatesales.gov, nothing in between. So realestatesales.gov and disposal.gsa.gov. And so let me tell you the differences between the two. Real estate sales, you'll be able to see all the federal real property that we currently have available for sale right now. And we typically convey or transfer about 150 properties a year. Most of them, I'm thinking 70 to 75% go to public sale. The other 25 to 30% go through one of either a Fed transfer, which is a pretty small sliver, or one of the public benefit uses. So you get a good idea of what kind of stuff we have available, when it becomes available. The other, disposal.gsa.gov, that is everything about my office. It tells you, again, all you want to know and more about the process that I've already described to you. But there's also links in that one to specifically sign up to get notices of excess property and to get notices of surplus property. And within the surplus property notice, I know for sure that you can designate that anywhere in the country, or you can designate certain states, things like that. So now I'll go back. Did everybody get that? Anybody need that still? Any other questions? You can ask me the most bizarre things you want about GSA or anything in DC. I will refuse to answer if I can't. Yes, sir.
Who's the tribal liaison? What's that person's email address?
Each of our regional offices has a separate tribal liaison. There is also one in our central office. I don't have that at the top of my head because that person in the central office, at least in the headquarters, was just appointed in the last 5 or 6 months, and I don't know her name off the top of my head. But if you would email me at richard.butterworth@gsa.gov, when I get back to the office sometime next week, I'll be glad to send that out to you. I can also provide that information to Nicholas I think there was someone else who was thinking about doing, what's the annual newsletter that was in our bags when we had signed in. I'm not familiar with it, but I guess you guys are. I talked with the guy who puts that together. He said he might include this presentation in that, and so if so, I'll make sure that he also has that information, so that it would be part of that article. And so, an easy way, like I said, each of our directors, I'm gonna go all the way back to the beginning, sort of. There you go. Each of our zone directors, they can also direct you to the person in that regional office. So they're a good resource, like even if it's not real property, even if you're interested in personal property, they can tell you that. Or if you're asking about a more programmatic thing, you can send that to me. I can forward it over to the personal property folks as well. I know that there's recently been a big push for bison restoration and the process of how bison can be transferred to the tribe. And there is a whole piece for agriculture and how that goes through our disposal process, but that's all over on the personal property side. Yeah. Yes, sir.
Under what category, with respect to this deal, did that pass an aquatic transfer?
So I think that was Air Force land. So it would have been on the last one where the and it was for economic development purposes, which is why they had to pay. Yeah. Yes, ma'am. You had your hand up?
Yes, you had mentioned that Forest Service is one of your entities that, what about Corps of Engineer?
So Corps of Engineer, it's interesting. Corps of Engineer has certain real property, like along the basins and things like that. When they determine it's no longer needed for those management purposes, then they also declare that access to us. And so does TVA has in the past as well. So, but typically a lot of the stuff that we do with the Corps also performs a lot of environmental services for the other services, and that portion doesn't have any real property themselves. But for along the ones that are doing it for management purposes, if they determine it's no longer needed for management purposes, they have some authority to convey that directly themselves, but a lot of it, I think they have to report that access to us. Any other questions?
Have you ever had tribes go for the same land? No.
We've not had that. I've not had that situation. Yeah, we don't have. In our regular process, there's an opportunity for there to be more than one request, right? Like more than one public benefit use, or more than one opportunity for negotiated sale, or maybe even more than one federal agency. But it just typically doesn't happen. So our regulations don't really speak to that. Quite frankly, we flip a coin. It's only happened 3 times in my 34 years. Yeah, so, but to get to that point, we would have to know what each entity wants to do with the property. Are they making use of 100% of the property? Are they prepared to take on property? Do they have any conditions that they would place in order to take the property? And then the one that makes the best sense would be the one that we would choose. But if they're completely equal and it doesn't fall out, then we have flipped a coin. Yes, sir.
On the transfer, is it, since it's federal, is it then trust land, or is it then, fee land in that state, or the tax implications?
Right.
I'm not gonna put a transfer out, but travels up to the NEPA prior to.
Okay, so on the 523 transfer, that's required to be when BIA acquires it through the transfer, they're required to hold that property in trust. So that's not a case where the tribe has to apply for that to be held in trust. Yeah, it goes in and should have trust status when it goes. Okay, so there's still, even in that Fed to Fed transfer, which really is a one-page letter. It's just us saying we are transferring and you are acknowledging receipt and the agency is being released, the original agency is being released. But it could be many other documents attached to it, because the two federal agencies may have a separate negotiation about what condition is that property gonna be in as it transfers from one agency to the other. And so that has been a case of, some instances where property has been held up for a while, because we can't, if it's within reservation boundaries, we can't do anything else with it. So it's not going on through our process because it's been held up or something. No, that's where it is.
So maybe if there was an economic development, probably possible purpose to it, might it be a little more lengthy process?
No, for that, if it's within reservation boundaries, it doesn't matter. You don't have to have a use, you don't have to have a contract, you don't have to have any purpose. It's just its status as within those reservation boundaries. And then we are required to send it, they're required to take it, it's no cost to the tribe. And it's in trust. Great. Anything else? Alright, I'm gonna go to the end. Well, if you think of anything else, please feel free to reach out to me, like you said, like you asked about tribal liaison, that if you go to the GSA website, all of those positions are listed there too. And each regional office has a separate website. So you can find them that way, but I'd be happy to supply them if you can't find them. So thank you. I'm gonna time. I started with a song, I'm gonna end with a song. So keep a song of joy inside your heart, even though the time has come for us to part. We'll be together soon, and time will fly, 'cause we never really say